Morning, everyone. I would like to extend to you a warm and cordial welcome to our last day of our second international workshop of the Network of Philosophy of Private Law held at the Externado University. Hope to close this important academic space with a flourish. Today, we will have two lectures, one by Professor Arthur Ripstein, entitled Public and Private in the Law of Public Nuisance, and the other one by Professor Diego Papayanis, titled Unequal Private Law Under Distributive Justice's Watch. We will end international workshop with a balance of the events and some closing remarks by Professor Alexander. Professors Ripstein and Papayanis, thank you very much for your participation in this workshop. On behalf of the Externado University, we are very pleased to have you here. Without further delay, we will start the second day of our international workshop with the lecture Public and Private in the Law of Public Nuisance by Professor Arthur Ripstein. Professor Ripstein has an MA from the University of Pittsburgh, an LLM from Yale Law School, and a PhD from the University of Pittsburgh. He is currently Professor of Law at the University of Toronto. Professor Ripstein's research and teaching interests include torts, legal theory, political philosophy, and Kantian philosophy. In addition to numerous articles in legal theory and political philosophy, he is the author of Kant and the Law of War, Rules of Wrongdoers, Private Wrongs, Force and Freedom, Kant's Legal and Political Philosophy, and Equality, Responsibility, and the Law. Professor Ripstein, thank you very much for your presence. I give you the floor.
Thanks very much. It's an honor to be here, and I want to begin by thanking the organizers for inviting me. And I have, over the years, had many elevated discussions about private law, but never at such a high elevation. So that's an extra delight. What I want to do today is talk about the tort of public nuisance, and I'm particularly interested in the way in which public and private aspects combine in it. Every tort action has a public aspect to it. It's brought before a court. It is tried under laws that are the laws of some particular jurisdiction or other. And then there's another way in which there's a lot of overlap between tort and public law, which is that many crimes are also at the same time torts. For example, the crime of theft is the tort of conversion. The crime of battery is the tort of battery, and so on. But there's a different way in which public and private interact in the tort of public nuisance, and that is my main topic for today. One of the things that is distinctive about public nuisance is that the rights that are at issue in public nuisance are rights that are fundamentally public in a way that I'm going to explain. One way of seeing the implications of this is that public nuisance has doctrinal features that make it very different from other kinds of tort actions. The one that's perhaps most conspicuous in the literature is the fact that in public nuisance, apparently a plaintiff can recover for what would be treated in other tort actions as pure economic loss. Let me give you an example of this with the English case from 1983 of Tate and Lyle versus the City of London. London had built a ferry terminal on the Thames. The Thames was authorized, the ferry terminal was authorized by statute, and it was understood that the building of the ferry terminal would cause a certain amount of silting. Tate and Lyle, which is a sugar company, had two jetties, one for raw sugar, one for refined sugar, and they silted up and required regular dredging as a result of the building of the ferry terminal. Because of this, Tate and Lyle incurred expenses, and so they sued the London Council in order to recover their economic losses. They sued both in negligence and in public nuisance. Their suit in negligence failed at the House of Lords. It was defeated on a motion to strike on the grounds that they had failed to state a cause of action. Why? Because, as the House put it, they had no right in the riverbed, as a result of which damage to the riverbed was not actionable in the tort of negligence. They had not suffer damage to anything that they owned. Their jetties were perfectly intact. They didn't own the riverbed. And so their loss was pure economic loss. But the House continued. They were nonetheless, the city was liable in public nuisance. Why? Because the Thames is a navigable waterway. As a navigable waterway, Tate and Lyle, as a landowner with land abutting the navigable waterway, had an entitlement to the usability, that is, the navigability of the waterway. And the building of the ferry terminal through its excessive silting had interfered with that. And so what was economic loss for purposes of the tort of negligence was not economic loss for the purposes of the tort of public nuisance. So this raises a series of interesting questions. And these questions are the ones that I will focus on today. The first of those is a question about who it is that is wronged in the violation of a public right, such as the right to the navigability of a navigable waterway or the passability of a public road, or various other examples that I will mention towards the end. So we can call that the question of outstanding. The question of outstanding has a special force because public nuisance involves public rights, rights that have, in a sense, I will explain, a structure as rights that every member of the public has. But then there's a question, why is it that this particular plaintiff gets to complain? There's also a question about what it is that the particular plaintiff is complaining about. In one sense, it's clear, the silting of the riverbed, for example. But in another sense, the question is, what's wrong with the defendant's conduct? So we have a question of outstanding. We have a question about the nature of the wrong. These two questions come together in a feature of the tort of public nuisance, which is called the special damage requirement. In order to sue in public nuisance, the plaintiff needs to show that they suffered special damage. And I will say a little bit about the specialness of that special damage. And finally, there is the question of why it is that there is a seeming exception to the supposed exclusionary rule for pure economic loss. So those are the problems that I hope to explore with you today. Let me begin then by just drawing your attention to the way in which I am thinking about the law of public nuisance and the law of torts more generally. Now, of course, I know that I was invited here because everybody knows what I think and that I am. I once gave a talk at NYU, and afterwards Tom Napier said to me, you know, over the years, we've had lots and lots of speakers who describe themselves as Kantian, but you're the only one, you actually mean it. And so I have the most extreme Kantian view. One way of characterizing the extreme Kantian view in the case of the law of torts is that the law of torts is exclusively concerned with transactions between persons. And so, as I always act it out for my students, the plaintiff comes before the court, points at the defendant and says, the defendant is not allowed to do that to me. And the defendant comes and says, who? Me? What did I do? And the entire focus of tort litigation is on the plaintiff's claim that the defendant did something to the plaintiff in particular. It's all about the particular transaction. If we think about tort law in terms of the particular transaction, we can see why, as a general matter, there could be no liability for economic loss in the tort of negligence, for pure economic loss. If I damage something on which you depend, but which you do not own, I haven't done anything to you in the relevant sense. I've done it to the owner of that. So too, if I breach a contract with someone other than you, of course, I have committed a wrong against the person with whom I had the contract. You may suffer losses, but I haven't done anything to you, because we always look exclusively at the relation between the parties. But that means that the standard cases of economic loss, and again, we can bring in Tate and Lyle, if you don't own the riverbed, the fact that I damaged the riverbed allows me to say in response, what? Me? What did I do? Because I didn't interfere with any right that you had. Now, in thinking about the tort of public nuisance, my focus will have to be on explaining what it is that the plaintiff has as a matter of right. And once we understand that right, we will understand standing to sue, we will understand the special damage rule, and we will understand why, in cases of economic loss involving public nuisance, this is not pure economic loss, but is instead actually consequential loss. And so we will get a further vindication of the Kantian view, which I take to also be just the traditional legal view, that law is about a transaction. And we will get a further repudiation of the functionalist view that the point of law is to provide people with incentives to behave in ways that are economically efficient. My friend Kathy Sharkey, who teaches torts at NYU and writes about public nuisance, says, as a matter of doctrine, it can't possibly make a difference whether the plaintiff sues in negligence or in public nuisance. To which my answer is no, it makes all the difference. So what is the right that someone has? So I've written about this at length before, but let me give you a simple version of the answer, or a simplified version. The answer perhaps not simple. The paradigmatic case of a public nuisance is the blocking of a public highway or a navigable water. That is the traditional case in Roman law, the traditional case in the common law, traditional case in civilian systems. The basic thought is that members of the public have a right to pass and repass on a public highway. And the wrong of public nuisance is an interference with that. Now, question, why is that a public right? So here's a way of thinking about it. Roads are a legal solution to a fundamentally legal problem. The fundamentally legal problem is that if you have private ownership of land, where private does not necessarily mean individual, the land could be owned by collectives, the fundamental feature of ownership of land is the right to exclude others from your land. But that means that every owner of land is fundamentally landlocked by all of their neighbors. If you want to leave your land, the only way that you can do so is by going through someone else's land. But your neighbor is entitled to determine whether you can use their land, which means they're entitled to determine whether you can cross their land. And so there is a systematic problem of people being dominated by their neighbors. This problem is not in any way cured by the fact that it is everyone's problem and everyone suffers it to the same degree, although there may be, in a certain sense, a distributive equality in this predicament. It is a non-rightful distributive equality. So what's the solution? Roads understood as public rights of way, so that each person can get from any location to any other location without requiring the private permission of any other individual human being. A road exists juridically as a system of rules of access, rules for contributing to upkeep, and so on. And from this abstract idea of what a road consists of, namely as a public right of way, that members of the public are required to maintain and that members of the public are free to use for the exclusive private purpose of passing and repassing, gives you the concrete things that we think of as roads. That is, they are the things on which you have these rights. These rights are correlative to duties on the part of everyone else. That is, you're not allowed to block the road. You're not allowed to use the road for a purpose other than passing and repassing on it. And of course, there are de minimis exceptions. And so as you're getting in and out of the taxi, of course it can block the road temporarily. But what you can't do is use the road for any other purpose. In the written version of the paper, I have a brief description of a wonderful case from Australia from 1952, in which a farmer plows up a dirt road and plants crops on. And that is obviously unacceptable. Why? It is an interference with the right of members of the public to pass and repass on the public road. It is also something we could describe, and it's particularly vivid in this case, as an inappropriate privatization of the public right of way. Why? Because on the one hand, there is a willful interference, but even if it's not willful, the fundamental point is that they are interfering with the availability of the public road for others to pass. But that means that each of us has a right to pass and repass on the public road, which then raises the question, is that a public right or is it a private right? To which the answer is, it's both. How are we to understand it as being both of these things? It is a public right because it is a right that does not depend on any affirmative act on the part of the right holder. It's a right that everyone has simply in virtue of being an inhabitant of the jurisdiction. It's public in the further sense in that it depends on this system of public infrastructure. It is not something that could be conceived in what in the 17th and 18th century was described as a state of nature. Because in a state of nature, there, on the Kantian view, no enforceable property rights, and so there is none of the problem to which public rights of way are a solution. So it is a right that you have. You have it in a certain sense, not merely against the public authority that needs to provide for the road, but also against every other user of it. That is, every other user of the road needs to do their part to leave the road in proper condition. Sometimes that means paying taxes towards maintenance of the road, but notice stopping at traffic lights, going the speed limit, and so on, are also assigned parts that we have in the system of social cooperation that constitutes the existence of the road as a legal thing. So that's what your right is. Next question, the question about standing. Who is it that has standing to sue and why do they have standing to sue? Because you might think, and you would be right to think this indeed, that if I wrongfully privatize the road, I commit a wrong against everyone. I block the road in Bogota and everyone is prevented from getting to their destination. Of course, there are some people, for example, the members of my family back in Toronto, who are not really inconvenienced by this because they weren't planning to use the road anyway. But the question is, if what's wrong with my action in blocking the road is that I'm failing to do my part within a system of social cooperation, why do you in particular have a complaint about it? Why isn't this just a public? So the way that the law has developed in the common law world to deal with this is by imposing a requirement of what they call special damage. The special damage requirement has mostly been consistently developed over the past 4 centuries, though there are a few cases where there was a brief period in the 1970s through the 1990s where it kind of went off on a detour. Let me say something about what's wrong with the detour, and then I will explain how it is properly understood. The detour consisted in the thought that something counted as special damage if it was different in kind from the damage suffered by other people. But that means that if the road became unavailable, well, it was unavailable to you and you couldn't get to your destination, but it was unavailable to everyone. So therefore, there wasn't. That can't be the right picture. Why can't that be the right picture? Let me illustrate with a story about the American philosopher Sidney Morgenbesser, who was once called for jury duty in New York. The prosecutor said this was a case involving police brutality, and in order to make sure that Professor Morgenbesser was not going to be a biased juror, the prosecutor said, I have just one question for you, Professor Morgenbesser. Have you ever been treated unjustly or unfairly by the police? Professor Morgenbesser said, Unjustly, yes, but not unfairly. Prosecutor. What does that mean? Well, it was during the riots at Columbia in '68, and a police officer, I was standing there minding my own business, and the police officer came along and hit me over the head with his billy club. That was unjust, prosecutor, but not unfair. No, it wasn't unfair. He was doing it to everyone. Of course, the point is, it does not cease to be unjust because it's fair. The fact that I'm blocking everyone doesn't mean that I am not wronging you in particular. And the fact that I'm wronging lots of people does not mean that I'm not wronging any one of them. It can't be that your right is contingent upon my not wronging someone else the same way. Otherwise, of course, an opportunistic wrongdoer could generate a permission for themselves by just wronging multiple people. That's not it at all. How are we to understand the special damage requirement? The key is to think about the way in which the right operates in the tort of public nuisance. Because the right is a right to use something. It's a restricted right to use something. You can only use it for the purpose of getting to your destination, even if your destination is just going for a walk or a drive. But if there is an interference with use, we have lots of law about that in the law of private nuisance. The leading case on this is actually the case of Sturgis and Bridgman, a case that has generated a lot of literature because Ronald Coase treated it as paradigmatic for making a point about transaction costs. But in fact, the case isn't about transaction costs. The case is about easements. And the case is about easements because it is a case involving a confectioner and a doctor who were neighbors. The confectioner had machinery that caused noise and vibration. The doctor built a new consulting room, and the noise and vibration from the confectioner's machinery interfered with it. The doctor sought an injunction to stop the noise and vibration. The confectioner said, I'm entitled to an easement. I've been operating this for 20 years without a complaint. And the court said, without deciding whether you could have an easement for a nuisance, you couldn't have an easement for a nuisance in this case. Why? Because for those 20 years before the doctor built his consulting room, the vibration was not a nuisance. Why? Because it was not an interference with the physician's use of their land. But if it wasn't a nuisance, then you can't get an easement because the physician couldn't have gotten an injunction. You can only get an easement for something that the other party, the servient tenement, was entitled to prohibit, but couldn't have gotten an injunction because there was no nuisance. What does this show us? It shows us that the core of a nuisance is an interference with use, not with possible use, because of course there was, as it were, a notional nuisance right from the start, but rather an interference with actual use. Let's go back to the road. So if you were driving on the road and I block it and you have to take a detour, or one of the earliest cases, you were using a navigable waterway and I blocked it and you had to carry your goods by land, I'm interfering with your use of the thing to which you have a right as a member of the public. On the other hand, everyone else, I'm only interfering with notionally. But if I'm only interfering with them notionally, then there is no wrong that is personal to them. And so they have not suffered special damage. Once we understand the special damage rule in this way, we then get an explanation of the third thing that I said I was going to explain. That is why there is recovery for economic loss in cases of nuisance. One of the early cases, the canal blocking case I just mentioned, is called Rose and Miles. The plaintiff in that case had to move his goods by horse and cart rather than through the canal. Because he had to move them by horse and cart rather than through the canal, he suffered economic loss. His goods were not damaged. They were in perfectly good condition. His loss was purely economic. However, he was entitled to recover because his losses were consequential on the violation of his particular right. Once we understand that, we can then understand how there can be recovery for pure economic, what looks like pure economic loss, without being a violation against the supposed bright line rule against recovery for pure economic loss. Because there is no such rule about economic loss. There is a rule instead about rights. The plaintiff can recover for a wrong that is personal to that very plaintiff. If you're entitled to recover for a wrong that's personal to you, then you are entitled to recover consequential damages for the wrong that is personal to you. What I've tried to explain is that in the tort of public nuisance, although the source of the right that you have sounds in public law, that is in fundamental conditions of sharing a legal order and fundamental terms of social cooperation, and although the wrong sounds in those same public things, that is in the defendant's failure to do their part in such a system of social cooperation, nonetheless, the wrong is personal to the plaintiff because the system of social cooperation is a system of providing for the conditions in which something is available for everyone to use. Once we understand that someone in particular can be wrong, and we understand further that they can recover for the costs that they incur as a result of them having been wrong. Let me just conclude, I think I have about a minute left, by saying something about, as it were, the second life of public nuisance, because of course public nuisance has taken on a life of its own throughout the common law world in the last couple of decades. And in the US, it has taken a peculiar form of being asserted in multiple cases and virtually never successful, because it's taken the form of levels of government with no power to regulate something, suing people who have created a problem for it. And so there was public nuisance litigation about lead paint by cities. There was public nuisance litigation about guns by cities. Cities, obviously, putting aside the US's crazy Second Amendment, wouldn't have had the power to regulate firearms anyway, but they said, it's the cost. And so too with respect to opioid litigation. And in every case, what they've tried to do is say, public nuisance allows recovery for pure economic loss. We don't need a right. Those cases have not gone very far. Here's the more, why is that? Because they didn't identify a right of members of the public that was violated. They simply identify a loss. The other place where it has found, I think, a more promising home is in other common law countries, most notably New Zealand. Full disclosure, the barrister for the plaintiffs in the Fonterra and Smith case in New Zealand was my doctoral student, David Bullock. There, he successfully argued public nuisance, and this is a climate change case. The public nuisance consisted in a special damage suffered by a particular member of the public through the wrongdoing of the particular defendant. Lots of doctrinal detail required, and he's merely prevailed on a motion to strike. But the key point is that there's a genuine legal issue because there's a right. Because, coming back to why you invited me, that's what tort law is always about. Thank you.
Thank you very much, Professor Ripstein. for this great lecture on such an important and exclusive topic as public nuisance. We will now begin the discussion with any questions that our attendees may have and they wish to ask directly to Professor Ripstein.
Only taught this paper twice. Earlier versions of it. The very hard. And
You caught it, but it obviously hasn't learned anything.
I always think it just pull you a little direction. But first, I'm going to share with him in two comments as possibly two questions. So one comment is, I think that the American public nuisance thing is stranger than you think, because what happened is the tobacco industry settled for $250 billion, which is not most people's ideas of not very successful. They gave me $250 billion. That's pretty successful. But what's strange about, and even the opioid litigation is in the billions in settlements already, maybe not, there's hundreds of millions, but it's pretty significant. And what's strange, there are some successful cases like lead paint in California actually succeeded, but what's strange is that you're not getting, and the parties don't seem to want adjudicative rulings. So in one of the opioid decisions, the case was settled on the basis of an intermediate appellate court ruling. And when the Supreme Court ruled, which was in favor of the plaintiffs, and the Supreme Court ruled against the plaintiffs, they did not upset the settlement. So what you're getting is a rather striking version of a kind of libertarian private government by contract, where the states, instead of regulating, are working out tort lawsuits against the defendants, instead of letting the legal system settle it for them, settle it with private contract. It's really quite remarkable. That's just a comment. The second comment is, although I know you love your word investor story, you want an example of the special injury rule working in its very peculiar way, which I don't know that is a thing of the past, but the case is the Exxon Valdez case. In the Exxon Valdez case, which is this vast oil spill in Alaska, an ecological disaster, the public nuisance claims, private causes of action for public nuisance were brought. One was by fishermen. The fishermen recovered because of economic loss. Another was by a native tribe that was devastated because their entire way of life depended upon the natural resources and access to the waters in that bay. And if they didn't recover because of too much damage, okay, and also it wasn't different in kind, it wasn't really any different from, say, Greg flying up to Los Angeles to go wandering around Alaska for recreation. So the party with the much more severe harm, because they were devastated for the duration of the oil spill, did not recover because their injury was not sufficiently different in kind, whereas the party with the more trivial harm, pure economic loss, they have serious harm if they're fishing with the pollution, but less than the tribe did recover. And I think that is the paradox that, like, I think it's newer people complaining about. So just a thought, if you want to use it for an example. But here's now I finally worked my way to a question. So there's a leading American case called One Meridian Plaza, and it involves a fire in a skyscraper in Philadelphia. It takes something like a year, I don't know exactly, to repair and rebuild the skyscraper after the fire, and lawsuits ensue. And what is a public nuisance lawsuit? And the public nuisance lawsuit is because in order to repair the building, they have to close the block so that everybody has to route around that block. And you can imagine different kinds of claims whose rights have been interfered with. It is the quintessential original core public nuisance example, interference with the public way. And there are people who commute and go by foot past that building. Now they have to reroute. So every day coming to and from the office, they're detour a block to get to their destination. And those people did not recover. Although I think intuitively we would say, well, they did have an actual right interfered with. It's not like your family in Toronto and traveling in Bogota. It's actual interference with your community. But they didn't recover. They were held not to have special injury, just to have to lump it as either their injury is, I think courts always help themselves to every reason they think favors them. So throw in, and it's just inconvenience. You should lump it, and it's just part of the general interference that the public suffers. It's not special. You don't get to recover for it. If there's a cause of action that protects it, it would be some kind of public cause of action. But who did get to recover was the shopkeepers on the first floor. And the court certainly cited public nuisance doctrine as an exception to the pure economic loss rule, because it said, the shopkeepers didn't suffer damage to their property. It's just that they're out of business for a year. So they get no customers, but they have no rights to any particular customers. What they suffered was an acute pure economic loss. And so in that example, pure economic loss, it's very hard to call it consequential damages. The reason it's hard to call it consequential damages is it seems, in describing it, we should say everybody who had to detour a block to and fro on their way to commute to work actually had an interference. They weren't the people who could have theoretically used it but never did, the public road. And so too did the shopkeepers. But the shopkeepers get a cause of action because they suffered a serious pure economic loss that counts as a special injury, whereas the inconvenience to the commuters just isn't enough. So the test of the violation of the right in that case is pure economic loss, and it's consequential damages. And so I think you would take the position that the pure economic loss rule, the exception to the pure economic loss rule, the way it's understood, actually defines the interference that counts as a violation of the right, or a case like Meridian, which is a standard American case. That is the standard American understanding of the pure economic loss. Of course, you can always say, raise it the Second Amendment, but I just don't think you can square it with the view that that's consequential damage.
Okay, so thank you for all of this. So I have a footnote early in the paper in which I talk about why I'm not going to talk about the American cases in detail. And at the end of the footnote, I refer to my colleague Ernie Weinrib's paper called Can Law Survive Legal Education? And it is, I say that in response to some of the twists and turns of American public nuisance cases in particular. I think that the Exxon Valdez case, the Fishers recovering, that's just the traditional rule. Why? Because one of the traditional common law rights that you have is the right to fish in tidal waters. You have that as a right as a member of the public. You don't have it as a private right. And so there is an interference with the right to do that. And in the same way that you, in addition to having the right to travel on a navigable waterway, if you have land that abuts the waterway, or if you are a licensee for land that abuts the waterway, you have a right as a member of the public to abstract water from that waterway. And all of that is a matter of the rights that you have as a member of the public. I actually think that the indigenous group to which you refer had a similar kind of right with respect to the features of the natural environment. And so I actually think that that case is just wrong. And I mean, that's one of the great things about having this extreme content view. I think just the next cases are wrongly decided. But the point is that they were asserting a right. And it was a right that is common to members of the public. And indeed, my recollection of that case was that part of their right involved fishing. And it was only the commercial fishers who recovered, because the court mistakenly thought that in order to recover in public nuisance, you had to show economic loss as opposed to showing other kinds of loss, and they didn't treat it as economic. About the One Meridian case. So one of the issues that comes up in public nuisance that on which common law courts have divided is whether those with property along a public road have a right that their customers be entitled to pass and repass on the public road, or instead only have a right that they themselves do, that only the customers do. My own view is that it is the people who use the road who have the right. Now, there is, of course, a claim in private nuisance if someone denies you access to your own land. And if someone denies you access to your own land, then you might have an action there. But I think that the cases that say, oh, it has to be economic loss to be recoverable, have just misunderstood the traditional doctrinal structure. Now, of course, as a Kantian, I also think that the law it requires institutional existence. And so I'm not saying that the United States is not kind of free to go off on a detour of its own about these matters. But my point is that the traditional law of public nuisance has this sharp distinction and does not treat it as a matter of economic loss, but instead treats it as actionable only secondary to the violation.
Thank you. Really fascinating continuation of your thoughts on public nuisance. And I think my question is not about doctrine or how cases sort of come out, but rather the implication for 21st century society from your metaphor of public roads. It seems to me that if you're right, it's a very important condition of life that one needs to be free from being landlocked and be able to travel. Does that not mean that the government, rather than private providers, should deliver and furnish electronic technology for communication? Isn't that the 21st century extension of metaphoric stretch on public roads that are geographic, literal?
So that's an interesting question, which you might not be surprised here. You are not the first person to ask me. And I think that the answer is we need to be quite careful in distinguishing several different questions. So I think that the idea that there are rights that people have as members of the public is certainly not restricted to public roads, nor I think is it restricted to even natural resources and so on. And so it may well be that the key right in the context of communication is that you have a right that no one be entitled to interpose themselves between you and those with whom you wish to communicate, assuming the others are willing recipients of your communication. And so all of that seems right. And so it seems like there is a way of extending this characterization to cover that case. However, notice that that's not the same as the question of who is going to provide the relevant infrastructure. Let me illustrate with one of the implications of this view is if we think about the nature of public roads, we actually get a characterization also of the nature of public accommodations. And going back to Roman law, there was a law, the law of innkeeping in Roman law, basically said the innkeeper needs to take all paying customers, assuming there's room at the inn, but does not need to accept anyone as a long-term resident. Instead, what the innkeeper is, and the same thing applied to ferry operators, is a node in the system of public roads. Now, of course, the innkeeper is free to go out of business. What the innkeeper has to do is, if they function as an innkeeper, take everyone in. So too with common carriers. So too, it seems to me, with communications carriers. And indeed, the same rule for innkeepers actually applied, again, beginning in Roman law, to public markets. Everyone was entitled to buy and sell in the public market square. And my own view that this is kind of another thing as part of a larger project. I know it's always cheating to say, oh, this is part of a larger project, but I actually think anti-discrimination law has its origin in this same kind of picture of rights that we have as members of the public. And the development of anti-discrimination law comes out of the way in which we have come to recognize that more and more of society is like a public open market. But in the same way, it seems to me clear that internet service providers and various other intermediaries, like these various platforms that I don't use, are occupying this public space in a way that, just as the innkeeper, on the one hand, can be in it for the money, but on the other hand, is not entitled to say, it's up to me, I have the right to exclude, so too with these various platforms. And also, I think there are interesting questions about the extent to which they are entitled to monitor what's going on. And we had a talk a few weeks ago about privacy, and someone was talking about how Google knows all of these things about your personal life. And I have this great example of Google, their algorithms, I just messed them up because I was working on this project that required me to read a bunch of 18th century German legal documents. And on Google Drive, you can click translate, and so you can translate from Gothic German to Roman German, so you can read it quickly. And so I recorded that about me. And after that happened, I started getting ads for heavy yard work equipment. At first I thought they were sending me all these things from wood chippers. At first I thought it was because I had recently viewed the movie Fargo, but that wasn't it. But the point is, should they be entitled to do that? And the answer is, they're providing a service to members of the public. You're right as a member of the public not to be subject to anyone's private choice with respect to your availing yourself of those things. It has to be the right way to analyze it. But saying that has to be the right way to analyze it is, of course, not okay.
Thank you, Professor, for your exposition. It's hard to disagree with you, but
People man.
I have a question. What do you think if I say that somebody can be special damaged without being deprivated of the use of his right? And what I'm thinking, and I'm thinking in cases in which somebody put at risk to other person. And when you was speaking, and I remember this article in the Civil Code, Colombian Civil Code, and the article 2359 that says that when a building is close to collapse, anyone in the town have the standing to sue the owner of the building to prevent the collapse of the building. But if someone is especially put at risk for that collapse, only that person has the standing to present legal action against the owner. Yeah. So that is not a deprivation of the use of the land, neighborhood, close to the building, but it's a position that is a normative force to give another use to his land, for example, to take precautions or something like that.
Okay, excellent. Thank you so much. Please email me the details of that section, because you said it was hard for you to disagree with me, and let me just explain to you why you're not disagreeing. So there are lots of common law cases like this too. And so, for example, if someone there's a case in which people have been throwing garbage into an empty lot and it smells terrible and it becomes the road is not impassable. It's just that the road is unbearable. And so no one can walk by. No wrongdoing on the part of the owner of the vacant lot, but rather there is an interference with the availability of the road. Now, how does that differ from your case? And the answer is, it seems to me it's the same case. That is, anyone can complain to the authorities. This is in danger of blocking the road. Why? Because that's just people informing the authorities of something that is an imminent threat to the public availability of the road. But now, the way that I would understand, and again, obviously, I haven't read it and I don't know the rest of the doctrinal structure in which it's situated. But the way I would understand the special damage rules operation here is exactly the same as the way in which I would understand the role of a quia timid injunction in a private nuisance, which is to say there will be cases in which, although the tree is not yet fallen on, or the infestation of animals in the tree or in the decrepit house hasn't yet infested my house, but I see it's going to happen, I'm allowed to do that. The health department can do that. And anyone else can call the health department and say, look at this house teeming with raccoons. You got to do something about it. But only I can get an injunction. But it seems to me that the same thing is true. I am the one whose way would be blocked. And so this is where it is genuinely imminent that it is about to collapse. That in that situation, I am entitled to an anticipatory injunction because I am the one who, if the building collapsed, would be entitled to claim in public nuisance.
Okay, yeah, in strict sense, you don't need the deprivation of the use of the right.
No, but it is, but okay, but again, let's do the analogy with the private nuisance case. My right has not yet been infringed when I successfully get a quia timid injunction. Instead, my right is about to be infringed. And what I need to establish is that my right, I need to establish on a preponderance of evidence that my right is about to be infringed. And so I can require my neighbor to abate the nuisance, even though it hasn't quite become a nuisance yet. But it is, as it were, a nuisance in progress. That's how I would treat this case.
Okay, thank you.
Thank you for your presentation and the paper. I really enjoyed reading it, and actually I'm not sure how much comment, but I will try because I was thinking we're talking. But I'm interested in the idea of standing and the relationship between standing and rights, because we could think of standing as acting on our own rights, but also you can think of standing as acting as representative of the public interest, where the representative of others' rights. And so when we think, for example, of prosecutors, this is basically what they do, no? They act as representatives of the public interest to which the victim is part of. And so I wonder if there is, well, of course, there is a distinction there in standing and also in the relationship of the rights, if it also doesn't depend on the kind of rights, because you think of individual rights, but also a category of distinction that is very common in the context of consumer law, collective rights or diffusive rights. No? We have this. Maybe it's more of the civil law understanding of the standing. But there is this idea of collective standing that is built up on a different concept of right. And so I wonder how you see this relationship, because if assume in these American cases that the public authorities, you're not sure whether they act as representative of the public interest, whether there is a right there or not. And so I'm wondering whether there is a need of more refinement on these two elements, standing on one hand and which kind of rights, and whether it's something worth thinking or not.
Thank you so much. So it's definitely worth thinking more about. Let me just do a little bit of thinking out loud about it here and now, and then think more about it in, as it were, a cooler hour. Here's the way that I, in general, think about standing in private law. So there's a totally fabulous book that came out last year about it by Tim Liao called Standing in Private Law. And it just it's totally amazing. So Tim's reading, which I think is right, is that normally standing follows the right. And then there is a non-trivial class of cases in which standing does not follow the right. And so third-party beneficiaries and contract are a clear case, but he also has an extended discussion of this unjust enrichment case in which the will was void, but it had already been paid out, and the heirs so if the will was void, there was therefore an action to be made in unjust enrichment by the estate, but of course the executor had no interest in doing that. Why? Because the heirs were horrific people, and the testator had left all of his money to worthwhile charities. And so the executor had no interest in bringing an unjust enrichment action. But question, can the family members under the statutes of descent bring an action? And the answer is yes, they can. Why? Because there is a right, and this is the person who is in a position to actually enforce that kind of right. So now, let's take that to the case of public nuisance. The key for analyzing it, it seems to me, is whether in these kinds of cases, we can understand the standing without first understanding the right. I think the thing that's so great about Tim's analysis is he said, no, it's a rights first picture, and then there are rules of standing that will sometimes allow someone other than the right holders. Now, particular case of public nuisance. In 19th century England, a public nuisance action could normally only be brought by the Attorney General under a relator action. And most of the cases, it turns out, were brought by, so the Attorney General basically just needed to sign off on it. And the cases, there are lots of cases involving bleach factories, and sewage from Birmingham was one of the leading cases. So it turns out that you had these wealthy people whose country houses were downstream, who were in the members of the same political party as the Attorney General, and so the Attorney General would allow these to be brought. But the standing the Attorney General had, although it was exercised in a way that we might, looking back on it a couple centuries later, find kind of questionable. Nonetheless, the standing was predicated on the right that the landowner had, not on the Attorney General somehow acting for the public. Now, I mention this both because it engages with what you asked, but also to draw attention to the way in which this, although they were brought by the Attorney General, they were the exact opposite of the eponymous picture of the plaintiff as a kind of private Attorney General. Instead, it was the Attorney General enforcing what is fundamentally a private right. Now to your question about, are these individual rights or collective rights? The answer is, in some sense, they're both, because they are rights that people have as members of the public. However, the question of public nuisance, plainly a public authority is entitled to require that a public nuisance be abated. Public authorities sometimes move slowly, sometimes do things of their own. There's some 19th century England cases of public nuisances that were also crimes that were brought as public nuisance actions because the criminal prosecution would take so much longer. And so that right in the 18th century, criminal prosecutions took a couple of minutes. Henry Fielding, as a judge, would decide 25 cases a day or something, but criminal cases a day. But in the 19th century, criminal process was slow. This was faster. So too, think about the climate change case. Is litigation a good way to solve the climate crisis? Well, maybe it is, maybe it isn't. That is, putting pressure on these large polluters, the largest polluter, the largest defendant in the Fonterra case. One of their arguments was, we're insignificant. We only produce 0.25% of the greenhouse gases in the world. One company is producing 1/400th of the greenhouse gases. No wonder there's a problem. But anyway, the point is, New Zealand kind of leads the world in environmental legislation. It's moving slowly. But the reason that Michael Smith can make a claim is that he has suffered a wrong. Now, is he partly funded by Greenpeace, would like to see more regulation? Is there a hope that this case will provoke more regulation? Yes to both things. But the success of the claim depends on the violation of a private right. And the fact that the private right has this collective element to it makes it more interesting in a certain way, but doesn't make it cease to be a private right and doesn't make it cease to be a wrong, personally.
Thank you for your presentation. I just have a very simple question. Not familiar with court law. If I understood you correctly, you wouldn't have a standing in public nuisance if you just have suffered a pure economic loss. Is that right? You need to suffer something more than a pure economic loss.
You need to suffer an interference with your use of the thing that is public.
Okay, but if you suffer a pure economic loss, you just don't have standing.
Well, it depends what you mean by it being a pure economic loss. And so if you suffer an economic loss that is consequential on your inability to, say, use the public right of way, then you have standing. But if you suffer a pure economic loss because someone else is unable to use the public right of way, you don't. So suppose I block the public right of way, as a result of which Alex is unable to deliver raw materials to your factory. And your factory, therefore, can't operate during this time. You have suffered then pure economic loss. I have not committed a wrong against you. The only way you can protect yourself against this is by having terms of your contract with Alex so that Alex can then suffer a consequential loss. But it is the same as if I Alex, I apologize for making you the plaintiff here because of all of this trouble. But if I negligently, I'm not going to injure you, I'm just going to damage your car. If I damage Alex's, or I guess it's raw materials, so it better be his truck. I damage Alex's delivery truck, he can't deliver the materials to you. You have no claim in negligence against me. Why? Because I violated Alex's right, not yours. So too, if I block the road, Alex can't deliver the materials to you. I've wronged Alex, but I haven't wronged
Okay, so we're going to this one. No, mine is just if there's time left over at the end. Okay. I don't go forever.
Yeah, you gotta watch out for these.
I have the same doubt, I don't know much about your post. A whole lot of this matter, but what I was thinking when I listened to your presentation was that maybe interfering with use depends a little too much on the description we make about how I'm using things. In the example you just made, you can say that a merchant on the island is using or availing himself of the bridge. Because since we have a bridge, I can receive my customers. You broke the bridge, now you're not allowing me to avail myself from off the bridge to conduct my business. This is one way to make problematic the distinction between, well, interfering with use or the use of others. On the other hand, I might not be using the bridge to transport my goods because my customers are coming to me. But if they cannot come, I will continue to deliver. So what is it? What difference does it make whether I'm actually using it, or whether my potential use is my second best? It's my second alternative. My second is always latent plan there. If my customers cannot come, I can deliver. When you break the bridge, you impair both my options. I cannot receive customers, nor I can deliver. So in this way, you convert pure economic loss into consequential damages very easily by describing the situation. And this is, I think, problematic. The first part, I love it, how public roads with the Kantian view about it. That's great. But when it comes to interference with use, maybe I need something else.
Okay, thank you so much, Diego. So I have a general comment and a specific comment. The general comment is that the law of torts is always sensitive to descriptions. And indeed, that is why so much litigation is the opposing parties trying to redescribe the facts to bring them within the scope of the doctrine that is going to be favorable to them. So in your case, if I was using the road, then, sorry, you were using the road, I blocked the road, you're no longer able to use the road. You were not using the road to bring customers. That is not a way of using the road. That is a way of relying on the actions of others. Your customers are not your supplies, they are human beings. You are not transporting them yourself. And so it seems to be easy in that case to say that I have not interfered with your use. Now you say, but I had plan B. My plan B was, as it were, to take the product to the customers instead of bringing the customers to the product. Which is to say, you're saying, well, you've interfered with it. Well, I wasn't doing it, but I would have done it. Why would you? Well, I would have done it because you did this thing which wasn't an interference with my right, and so I would have coped with it by. But notice that in that case, I'm not interfering with your ongoing use. I'm interfering with your possible use. You weren't using it. I didn't require you to redirect. All I did was fail to provide you with the conditions in which you could have redirected had you needed to redirect, which you didn't need to do if I hadn't done the thing. And so you can't, as it were, bootstrap and say, well, my plan B that therefore becomes my plan A, because your plan B is not a plan that you could possibly have had, because it is conditional on a condition that was not met. And so you say, I'm going to deal with this problem in the following way. It's like the joke about the people trapped on a desert island and they find a can of food. The economist says, well, we'll assume a can of it. You can't assume that it's available and then say, well, assuming it's available, because that isn't the right description. And so that's why you can't, it's sensitive to the description, but you can't just, as it were, help yourself to the most favorable description of what you would have done, because you wouldn't have done it if I hadn't blocked the road. But you can't say, well, if you had blocked the road and the road was still available, this is what I.
That was not saying exactly that. I mean, suppose Pavilion. People, and
No.
I'm not assuming that the situation in which the bridge is not blocked. That's a precondition, I understand.
Yeah.
But I'm not saying, I'm saying, in general, I'm willing to receive my customers. And in general, if they don't come, I'm willing to deliver. Pandemic, they cannot move, but maybe I can get a special service, as it was in this case in Spain, they could transport fruit and food to supermarkets, so I can move now. But now they destroy the bridge, what difference that makes in substantive terms? I'm using the bridge for my business, or availing myself.
Okay, but look, so if you're doing it for both, then you can recover for the part that was your use of the bridge, but not for the part that was your customer's use. And so the fact that your use of the bridge was interfered with, yes, of course. The fact that there was something else that also happened, that's just pure economic loss. And so there will then be a question, well, how much would you have used the bridge? But there, as in any kind of inquiry of that kind, you have to ask what the baseline is. And the baseline would have to be there being no public nuisance, by not having blocked the bridge. And so the part of your economic loss that is consequential on your being unable to use the bridge, of course you can recover, but not the other.
But very good discount. I think that the idea of use is very broad. I'm using my stuff even when I'm touching wire. Using my cell phone now in a sense. Determining which way.
Yeah.
Yeah,
But your other your old phone that's sitting in a drawer in Barcelona, you're not using it. But also
not for you to judge.
maybe, but the other thing is that's because it's your property. But now the
My
road
right
that
to circulate.
the road that you take to get from Girona to Barcelona, which we had such a lovely drive a few years ago, you're not using it. Maybe you're using your cell phone now. Maybe you're using it as a paperweight in case it suddenly gets windier. But you're not using that road. Your property is something with respect to which you can be wronged even when you're not using it, because you have both possession and use of it. You do not have possession of the public road. You only have the use of it. Not only that, you only have the use of it for the specific purpose for which it's there.
I think we could go all day, but I'll try not to. On the Exxon Valdez, I think pretty completely to do that. It's unhappy in what turns out would love to solve that. But I think following up on Diego's point that you're giving a description that doesn't really respond to the position the court has. Here's how. It's perfectly true that the native tribe had its right to use interfered with. But the essence of the pure economic loss rule is to say you need more than actual interference. So suppose that Greg, who doesn't know how to fish, but could learn how to fish and could fly up to Alaska and could fish, but can't because of the Exxon Valdez oil spill. He doesn't have interference. But people who live around the bay and would normally recreationally fish there or for subsistence fish do. And that's interference with their actual rights. They're like the people who are in the vicinity of One Meridian Plaza and have to detour every day, twice a day, and it takes extra time. And that's just not enough. You have a rights violation at that point, but you don't have enough with a private cause of action. You have to have the pure economic loss. It's the pure economic loss is not a consequence on the for having recognized an action interference with your right. It is the interference that triggers the right. Not consequential damages, but so maybe we're stuck at a description problem, but I think American courts would not describe, reject your description of the Exxon Valdez, and that doesn't really fit the way the Exxon Valdez puts it. But the second one that opens us to different terrain slightly is transaction, a very strong word to describe both private nuisance and public nuisance, because the most distinctive thing about them in some ways is their conditions. That is, the most interesting nuisances, it's probably possible to have nuisances that are very difficult to distinguish from negligence, where somebody interferes with the use of property, but it's just kind of short-lived and one-off interference. We tend to absorb all that into ordinary negligence doctrine, but we treat nuisance doctrine as an ongoing interference condition. That's true in Exxon Valdez, it's true in Meridian, it's true in the really big cases involving opioids and lead paint and tobacco. And so it seems odd to describe enduring conditions which invite the most characteristic remedy for nuisance, which is abatement. That's the most characteristic remedy that nuisance attracts. And you know, it's not available as a in connection with negligence. As negligence, the characteristic incident is a one-off accident that you can't enjoin. It seems very aggressive to describe that as transactional in the way that you might describe a one-off risk imposition resulting in harm in negligence as transaction.
So always like to have my view described as aggressive. So let me forgive me for being defensive. But here's why it is transactional. I go back to the little skit I do for my torts students. Plaintiff says that defendant is not allowed to do that to me. Do what? I can't sit in my backyard. Or the Boomer case, I can't breathe in my house. This is a case where there's about 1 millimeter of dust a day, and that makes it through cracks in the windows because it's such fine dust. What have you done? What the defendant is not allowed to do in the private nuisance case is interfere with the plaintiff's use and enjoyment of the plaintiff's land. That is a transaction. It is what the defendant did to the plaintiff. What? Interfered with. So too, in the public nuisance case. A public nuisance can be ongoing or it can be short-lived. The early cases involved blocked canals, ditches in roads, and so on. And those sometimes were there for a long time and sometimes were there for a short time. Because again, it is a nuisance to block a private right-of-way. If I have an easement to cross your land to get to the beach and you put up a gate that is and block it, that is my only action against you is in nuisance. Now, because of that, it's a violation of a right of way, same thing in the public case, and same transaction. And again, the reason that in a private nuisance, ordinarily, it will be ongoing. Nuisance is a tort against the land. It is the relation between one landowner and another landowner. And it is normally going to happen when it is ongoing. But although some of them can be treated as negligence, blocking the private right of way, there's no negligence action. It is entirely a new private nuisance action. Now, coming to the Exxon Valdez, the requirement that there be economic loss looks to me like it is one of two things. The first possibility is that it is just a doctrinal confusion saying, oh, we want to protect certain kinds of economic losses. We don't have a systematic reason. And so in some of the fishing cases, you get judges saying, oh, well, fishermen have always been favorites of the law. No analysis, just that kind of thing. Oh, well, let's make this person a favorite too. And again, you can imagine, though not saying that in the Exxon Valdez case, oh, well, fishermen have always been favorites of the law. Native Americans have never been favorites of the law, so therefore. And that's probably what they were thinking. But Here's the other way of thinking about it that is perhaps more charitable towards their analysis. That would say they're treating economic loss as a proxy for something being more than de minimis. The fact that you can't go spend your afternoon fishing there, yeah, get over it. So too, the fact that if there is a public nuisance as a result of which you need to take your stuff off the barge, get another barge, load it into horse and carriage, carry it around the obstruction, put it in the new barge, that's major. On the other hand, the fact that you have to take a slightly different route that is 30 meters further, that's de minimis. But that is poorly captured by saying that one is economic loss and the other is not. And it seems to me that on either, or these are just our prejudices view, that's the wrong way to do it. Or alternative, this is just a proxy for it being more than de minimis. And so it seems to me that there are lots of de minimis cases of public nuisance where a legal order requires that there be a lawful way for members of the public to get from any location to any other location. Almost every urban area is going to be redundant with respect to that requirement because there are going to be lots and lots of different routes available. And so if you merely need to take a small detour, that's going to be de minimis. But it seems to me that focusing on the economic case doesn't actually cover it at all. It seems to me that is giving up. And again, this is why when I talk about the American cases, I talk about Bernie's article, Can Law Survive Legal Education? Because if you try and do things in a purely functionalist way, then it turns out something will count as a public nuisance. I mean, this was kind of Prosser's view. If you can just put whatever, it's just a residual category. And my view is, no, it's not a residual category. It actually has its own doctrinal structure. And whereas if you say its doctrinal structure is you can recover for pure economic loss without the violation of a right, then that's not a doctrinal structure. That's just saying these are just the prejudices of the court, because they say in general you can recover for pure economic loss, but in this case you can. Why in this case? Because there's pure economic loss. That's not.
No, here's the thing, the third view, I agree with you on the prejudice view. And one worries that the prejudice view is actually the view that, given that the American treatment of Native Americans was genocidal, there's some reason to worry that they're not favorable. I just wasn't going to describe it. But the doctrine position is a third position. And the doctrine position is this. It is that you need more than a rights violation, which would be sufficient for establishing a public nuisance. But for the private cause of action, you need a rights violation plus a harm. And the harm that will do is pure economic loss. You don't need to show physical harm in the form of damage to property you own. So if you put the fisher in that category, they don't have to establish that they own the fish, which would be an impossibility. All they have to establish is that they've suffered pure economic loss, but they already have. We're assuming that you already have established by the existence of public nuisance the violation of a right you have, which happens to be a public. But you've got the rights violation.
Okay, but if you've got the rights violation, then you have to show that it's not de minimis. Then it just goes back to using economic loss as a proxy for it being de minimis. Again, think about the case in which the road is blocked, as a result of which I am unable to get to my land, but I wasn't using it for any economic purpose. or I need to take this major detour. And it turns out that I can't show a financial loss because I was just out cycling. And you can say in response, oh, well, look how it improved your fitness. You got a longer ride in. But it took me an extra day. Yeah, but you weren't going to make any money anyway. That doesn't seem like the right way of putting it. And so the idea that the loss that there needs to be loss, yes, that the loss needs to be financial, that can't be more than a proxy.
It's the minimum. It defines the minimum. But it also sets out why Kathy, you and I don't like Kathy's position. But you just gave the reasons why Kathy's position is quite a plausible position, which is that you clearly interpret it just the way you said it. So I think you'd be better off interpreting as you could interpret the pure law school life. Oh, this is a commercial court. You get recovery when you had a financial loss, but if you're just out recreationally cycling or recreationally fishing or recreation, anything else, forget about it.
Yeah, but it's not, again, doctrinally, again, there are these, as I keep saying, the American cases have gone off, as it were, on a detour, maybe a frolic of their own. But the idea that doctrinally, if you look at the development of the doctrine, that's not what it's about. That all of the 19th century cases are cases, some involve economic loss, and some involve gentry who wanted to be able to water cattle from the river. Why do they keep cattle? Well, because a good country squire has cattle on his land. And owning the cattle was in fact a net economic loss to this was conspicuous consumption. You would have a bunch of peasants who would care for your cattle. Why? Because I'm a country squire. That would be blocked by the economic thing. To say, I mean, Kathy calls it a modern business tort. But again, it is a consequence of her view that the same rule should apply for negligence as for public nuisance. Why? Because the only way you can explain these cases that she likes is by making it merely about efficient allocation of resources. And that's not what the traditional law says.
So this is the point at which we agree, because we disagree on it. Yeah, we both agree on it. But the point that you're aligning is that the pure economic loss rule is a threshold rule that defines a minimum interference that will count as sufficient interference.
Wait, you can't call it a pure economic loss rule. You mean the consequential loss.
No.
It's not pure economic loss if you have said that you're going to agree with me that there has to be a rights violation.
I of course agree with you. I'm just giving
Yeah, no, but if
the description of the American
courts agree with me that there's a right violation, they can't also insist that the economic loss is pure.
Sure they can. They can say that because what the pure economic loss rule means is there isn't physical harm. You don't have.
Yes, but again, that's physical harm is not a relevant thing. Rights are the relevant thing. Physical harm matters because you have, in the tort of negligence, a right to the integrity of your body and property. It's not that we say, oh, we have one rule about physical harm and we have one rule about economic loss. We have one rule about rights. That is my claim. And if you say that this is an exception to the economic loss rule because the economic loss rule is about physical harm, then defamation is an exception to the economic loss rule. Liability and trespass to land is an exception to the economic loss rule. That's not the real rule.
Oh, okay, but that's a far normative position.
No, but
It's just not an understanding of it. It's just a misunderstanding of what American courts are saying.
yes, and again, that's why I said I can't explain what American courts are doing. It's like when I discuss defamation, I say I can't explain what American courts are doing with defamation because they've abolished the tort of defamation.
But here's the thing, it's not hard to explain what American courts are doing, okay? It's just that they're not doing what your normative theory calls for them to do. It's easy to explain it. To explain it is to say that you normally recover in negligence for pure economic loss, and that's for physical harm, and you don't normally recover pure economic loss, though there are many exceptions. Okay, and then it looks at public nuisance. It doesn't see in public nuisance a freestanding separate tort of the kind misrepresentation or defamation are, and it says, well, the way that the pure economic loss rule functions in public nuisance is the way that it functions in negligence, which has it's a scope of responsibility rule that says you can have a right interfered with, but not with a private claim. And in order to have a private claim, you have to have more than interference with a right. You need what counts as a harm. But here, harm does not require physical harm. That's not your normative position, but that is their position.
Yeah, please sum up with.
Yeah. Yeah.
We have to take the copy.
Yeah, okay. So,
Thank you very much, Arthur. A short comment is about the nature of a use. Perhaps the nature of nuisance depends on the nature of property. It seems to me that the dual nature of property communicates to the nature of a nuisance. Therefore, in both cases, the law of a nuisance is private and public. Its nature is dual, like property. Thank you very much.
so I think I'm not sure I fully follow what you're saying, but property plainly has a public dimension to it. But there can be an interference with property that is exclusively private. That is, when I make a loud noise that regularly keeps you up at night, that is an interference with your property. And it's purely private in the sense that it is just between the two of us, between the two of us as neighboring owners or occupiers of land. By contrast, it seems to me that there is an inescapably public dimension with respect to public nuisance, because there is no private matter. It is rather, there is a private matter within the context of the public rights. And so the public aspect of property is that it exists within the structure of a legal order in a way in which the public structure of public nuisance is public in a further respect.
Thank you, Professor.
Yeah.